When you apply for probate, you're asking the court to name you as the person with authority to deal with the deceased's estate assets. So it makes sense that part of the process involves describing all those assets in detail. You do this by completing a form called an Affidavit of Assets and Liabilities in Form P10 or P11 and filing it with the probate registry. The registry uses this form to calculate the probate fees you might have to pay. Here's what the form looks like. You'll need to complete this first page, giving information about yourself and the deceased. I've filled this part out in advance, so you don't have to watch me type every detail in. At the bottom here, you'll also have to indicate what kind of grant you're applying for. So I'll select Grant of Probate from the drop-down menu. At question 7, you'll need to indicate whether the deceased had real or personal property located outside of BC. This ties into further questions below. Next, you can start listing the estate assets. Question 10 is about real property within British Columbia. Basically, real estate. There's no need to include any real estate outside of BC in this question. The form provides a great example with the information you should include for each property. You can see that right here. And here you can see that you should be listing any mortgages as a negative value against the relevant property. A common item is the deceased's home, but don't list an interest in land that automatically passed to someone else from the deceased when they died. For example, spouses often own a home jointly, and such a property wouldn't need to be listed here. You can add more line items as needed, or delete any items you don't need. Question 11 is about personal property located within BC. These are any physical assets that are not real estate. List things like jewelry, furniture, valuable art, or any vehicle the deceased owned. If there are any secured debts, you should include those as well. For example, if there's a secured car loan, list it as a negative value against the car. If you're not sure whether the loan is secured or not, see if you can get a hold of the terms of the loan. Here's an example. A lender can sell the asset, for example, a car, if loan repayments aren't made on time. That's a secured car loan. Moving on to question 12, which is about intangible personal property within BC. This is just another way of saying non-physical assets, things you can't hold or touch. Things like shares or bank accounts would go here. Note that despite the heading, the question also asks you to list any intangible assets outside of BC that are not dealt with by a foreign grant. A foreign grant is any grant of probate or administration that's in a province or country outside of BC. At question 13, type in the gross value of this state in BC, less secured debts. Do this by adding up the total values in questions 10 to 12. Question 14 and onwards are about certain assets the deceased owned outside of BC. Fill these out if relevant, though you won't need to pay BC probate fees on these assets. After that, click the Preview and Sign button. And here's the document that's been generated for me. This is what it will look like when I print it to be filed with the registry. So I'll just scroll down to the second page. And here you'll see that the assets and liabilities have now been compiled into a table. Great. Now review your form and print it when ready. You'll need to sign the form in front of a lawyer, a notary, or a commissioner for taking affidavits. When doing this, you'll be swearing that the information in the document is true. Here are some quick tips. Tip 1. You generally don't list assets that are owned in joint tenancy. Common examples include a joint bank account or the family home that passed automatically to the deceased spouse. As well, you usually don't need to list assets that name a specific beneficiary, such as a life insurance policy or an RESP. There are some exceptions though. For example, if the intended insurance beneficiary has died too, or if there wasn't another adult named to take over the RESP, these funds would form part of the estate, and you'd have to report them on the P10. Tip 2. You're cataloging the deceased assets. Imagine you're taking that snapshot on the day they died. Say the deceased died a year ago and the market value of their house has increased. You should write the value of the house then and not now. What if someone refuses to give me information? Someone holding the deceased's assets, such as a bank, may refuse to give you any information. If this happens, you can still go ahead and file all of the other application documents. Just leave out the Form P10 for now. At the same time, you can apply for authorization to obtain estate information using Form P18. If the court grants your request, third parties must give you information relating to the deceased's assets. For more on each step in probating a will, visit peopleslawschool.ca.